Hi, guys. Happy New Year. It's Kathy. I hope you're doing well. I hope you didn't celebrate too much last night, this morning, an hour ago. Well, welcome to 2025. This means in exactly 3 or 4 months, I'll start writing 2025 on documents. Time's ticking on 2024, let me tell you. All right. This Delusions of Grandeur guy is great. You'll see him. He's not up yet, but um, I love him. I got him a couple days ago, or a day ago. I can't remember. And I missed him yesterday. I tried to find him yesterday. I couldn't find him, so I did find him for today. And this my green screen and my camera hate this color that I'm wearing. It doesn't know whether it wants to get rid of it or keep it. Ah, that would be me. That'd be me. Yep. Yep. 3 more months. Remember when we used to have checks? That was really difficult. All of our checks in January were the wrong year. But the checks kept us in line, and now we don't have to write the year anymore. The phone does it for us. Yes. Yes, at some point, I think if I stay still, nope. If I move around, nope. I don't know. If Mars is hitting Venus, then my shirt goes see through to the back screen. Just to the green screen behind me, in back of me. My shirt does not become see through. Let's go to California.
All right. For this matter, on the record.
Oh, that just sucks, Bobby and Donald, because in 2024, if you would have said that, I would have done it. But now that it's 2025, I have a resolution not to flip my shirt up.
All right. On the record, calling the matter of People versus Charles Whitcher. Mr. Whitcher is present in case CR 2415338 on bail bond now, represented by attorney Mr. Ma. Ms. Sharifi here for the people. Time for preliminary hearing. What's happening?
Your Honor, if please just trail it to the 10th day, which is tomorrow.
I chose to attend it. Do you have good cause and continue it or something?
Well, the 10th day is tomorrow, but defense won't stipulate to DOJ, and I did not have the officer there for
Yeah.
DOJ for
Not stip- Okay. Not stipulating the DOJ?
No.
All right. Let's go off the record. So if you have good cause, I could continue it. He's out of custody.
He's on, well,
He hasn't waited 10 days, Your Honor.
So what? You read 859B?
Our position is that it should be within the 10 days.
Well, yeah. And that's if there's not good cause, but, you know, well, you're jamming the court. So that's my point on it. Your client's out of custody.
He hasn't waited within the 10 days. Our position is that he's
Right.
subjecting to the continuance.
Well, if you're going to quote the law to me, make sure you quote it right, okay? All right, let's go back on the record. But a brief outdoor discussion of requests is the trail to the 10th day. No one's making a motion to continue. So Mr. Richard will put it over to tomorrow. That'll be December 31st, 2024. You can remain on bail or to be present. And that's the order. You're going to see it out in the audience. Wait for your paperwork.
This judge is not done with this lawyer. He has more to say.
Before you were, I'll get your paperwork for you.
What about you guys do over there? Just jam the calendar, Mr. Mott? We're all trying to work together. You got your client out of custody.
Sorry, Your Honor. I won't jam your calendar anymore, Your Honor. That poor lawyer. If you're going to quote law with me, you better know it. Oh, man. Oh, if you guys... Okay. What is your New Year's resolutions? Start typing them in chat. New Year's resolutions. I have 0 New Year's resolutions. I don't do that. But what are you guys going to do? You never know when a nose picker will show up. And I'm not going to tell you if one's going to show up. It spoils the fun. Me neither, Randy. Me neither, Beck. I felt like I had to. I felt like I had to ask. Maybe someone's doing something big. Yes, 11 more. 11 more, and I can stream to Facebook as well as YouTube. Good job, Monica. I'm going to do yours. All right, let's do this one.
Thank you. Good afternoon, ma'am. Please say your name.
Good afternoon, Carolina Rojas.
Thank you. Mr. Rojas, you are arrested for domestic violence, battery, and there is probable cause. PTR, any history?
Yes, Your Honor. The defendant has one arrest in 2014, a DUI.
Just remember, judges are supposed to be nice to victims. When a victim comes in to give his opinion, judges are supposed to be nice to them.
And a guilty conviction on count 2, which is the DUI, count 2 was dropped, but count 1 was a conviction.
Understood. Thank you. State.
Your the victim in this case is present, and he has indicated that he would like to speak to the court. At this time, the state would be asking for no contact due to the fact that the incident occurred so recently that the state believes that a cooling off period is necessary. In addition, the report alleges that there was a prior incident of domestic violence approximately 2 years ago where Roger was arrested. And Your Honor, the state would also be asking for an additional condition of no alcohol, as there was alcohol present at the time of the incident.
I could never marry a man named Roger. I just couldn't. 10 years later into the marriage, it would be the same thing every day. Roger that. Roger that. Anything that comes out of his mouth. Roger that. Roger, Roger. Nope. He would have to pick it. He would definitely pick a different name or divorce me.
Thank you. If the listed victim wants to make a statement to the court, that's perfectly okay. I'm just going to need some sort of a ID so that I can verify identification. Sir, if you'd like to come forward to the podium, you may do so.
You can play on stream. I'll let you.
No, sir, right up here. Thank you.
Did you ever say Roger that to your dad? Go clean your room. Roger that. It's time for dinner. Roger that. Yeah, now I really have to marry someone named Roger. That's my New Year's resolution. I'm going to marry someone named Roger.
Thank you. Can you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please lower your hand and tell me your name?
Roger Official.
Thank you. Mr. Official, you're the person who's listed in this affidavit as the victim. Is that correct?
Yeah.
Okay. Sir, how old are you?
44.
And what do you do for work?
Financial advisor.
Okay, and how long have you known Ms. Rojas?
4 years.
For the record, he has shown a driver's license in the name of Roger Official and appears to be the gentleman who's standing in front of me. Thank you, sir. What would you like to say?
I'd like to say that, this is a whole big misunderstanding. Carolina is not a violent person at all. And the only reason the police were called was to protect her because she was very intoxicated and her friend's boyfriend was taking advantage of her. And I didn't know what else to do to be able to stop that. The scratch on my face was caused from her coming towards me and she slipped on the pool. It wasn't a direct result of hitting me.
So you didn't tell the police that she slapped you?
I told the police the whole story. I said she was slapping at me.
But you didn't tell them that she slapped you?
No, I said she was slapping at me.
So when they wrote that in their police report, that would be a lie?
I read the police report, and it was also said in there that her friend's boyfriend was taking advantage of her.
Yes, sir, I read that too. I'm just curious. I want to make sure that I understand that. The officer wrote that he was told Carolina got out of the pool and slapped Roger in the face. So you did not tell them that she slapped you?
I told them that, yes.
Okay, thank you. I appreciate that. Anything else that you'd like to say, sir?
No, she's not a violent person.
You, in fact, showed the police officers a video. Is that correct?
Yes, there was a video of her trying to knock my phone out of my hand.
And the officer wrote, if you said you read the report, the officer wrote, Roger advised that he had been slapped several times while recording. Was that true?
I don't believe I was slapped when I was recording, no.
Okay, I appreciate that. Steve, do you have any questions that you'd like to ask?
Yes, Your Honor. Sir, do you want no contact with the defendant?
I don't mind. Like I said, she's not a violent person. I have no concerns for my safety.
Understood. No further questions from the state, Your Honor.
Defense, do you wish to inquire of the witness?
No, Your Honor, not at this time.
Thank you, sir. I appreciate you coming. At this time, the court's going to set bond at $2,000. I'm going to order that there be no contact with the listed victim. Sir, you can't use your phone in the courtroom. Thank you. No contact with the listed victim. No return to the shared residence, but you can go back one time with an assist order to get your personal belongings. No weapons or firearms, and no alcohol. Next court date will be? Thank you.
Yeah. You know who I'm never going to marry? Someone that makes me say Wilco. Nope. No. I will not comply. You can't make me. She was very mean to that. She is very pretty. She is very pretty. She was very mean, and she was, even her voice matches how pretty she is. Okay. That judge was very mean to the witness. He was just yelling. I mean, he was just telling his story. All right, this next one is in the same jail, but we don't get to hear him speak at all, or he mumbles a little bit. Not a big deal. It's just, we're just going to watch this inmate for 2 minutes and 23 seconds.
He approves.
Good afternoon, sir. Please say your name. Thank you. Mr. Lance, you have 2 booking reports. You have 1 arrest, which is a warrant arrest for dating violence, domestic violence, battery. The judge who issued the warrant found probable cause. And then you also have a new law charge of possession of methamphetamine, possession of paraphernalia. I read that affidavit. There is probable cause in that for your arrest. Pre-trial release, any history?
Yes, Your Honor. His history starts back from 1999 until 2024. In 2022, he had a DUI that's dismissed. He has an assault in April of 2022. Judgment, it was guilty. I don't have what he was given as far as the disposition is concerned. He also has an aggravated battery on the EMT, aggravated battery of a peace officer, driving while license suspended in 2023. That was filed. In 2024, he has a battery, touch and strike, Osceola County, no info. Obstruct with violence, that is guilty, yet time served, and drug possession in Osceola in 2024. That was also guilty with time served, and drug equipment possession for Osceola, no cross. Yes, history out of the state of California from 2003 through 2004. I have no disposition, Your Honor.
Thank you. The dating violence will be set bond at $1,500. No contact with victim. No return to the scene. No weapons or firearms. And the new law charges will remain stayed, 5,000 count 1 and 1,000 count 2. Next court date will be
On demand. I'm sorry. Next court date, if in custody, January 2nd. Out of custody, February 14th, 8:30 a.m.
Thank you. Thank you, sir. Ruben.
That man screamed attitude. Where's my microphone? Okay. Scream. Screamed man. Okay. We did that. You want to see a pro se that's... Okay, remember yesterday, I think it was. I really hate when I have to pick a day. Or the day before. We saw that one judge and I said, this is her courtroom. Hold on. You'll see what I mean in a second. This is her back in her courtroom. And this pro se, we got a pro se, but he does a good job, even though I think he's lying. Yay, thank you, Fozzie.
This is cause number 22012308F61006, State of Indiana versus Andrew Rogers. Mr. Rogers, raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
You got Bobby.
Thank you. Please tell me your full name. Thank you. The court shows that the defendant appears in person as a self-represented litigant in the state of Indiana, appears by DPA Sandra Cassidy. And I show that we are set for a final pretrial conference for a jury trial scheduled on January 14th. All right, Mr. Rogers, are you ready to go?
I'm ready, but I don't know paperwork I need. I should have for the trial. Same stuff that Bridget, y'all represent me. I don't have none of the paperwork. I went down last time. They gave me a note to go down and ask for. I still have, the only thing they gave me is a summary, basically like a summary of from what the police officer was saying, they statements and all that and things like that. With been trial and Ryan said all that, just the statements from the officer. I never got no audio. They said I can't get the audio. Anytime I want to see the audio, I got to go down there to see the audio. I don't understand why I don't get copies of that, because I got the same rights that a lawyer got. So I should have access to that, my personal access. I can't get copies of like motion discoveries and affidavits and all that. Yeah, so I understand how that will.
What do you said you have summaries of police reports?
Yeah.
Okay, what else do you have besides that? Okay, Ms. Cassidy?
I haven't been a part of these negotiations with DPA Gruber and Mr. Rogers. I am aware that Mr. Rogers has been to our office multiple times. And I know that DPA Gruber has met with him multiple times. And I know there were discovery meetings. I am positive that the audio and any video was made available to him to watch or listen to at the office. So to say that he hasn't had access to that is simply not true.
Well, Ms. Cassidy.
Love, you should have stuck with that line, what you just said, and died on that hill, because you're right. You're right. You should have died on that hill. You should have started singing that louder and prouder the whole time. Now this judge is going to get you.
Yeah, I don't see anywhere the state of Indiana has filed any type of like a protective order or anything like that. And if these are verbatim statements or audio the state intends to play either in portion or its entirety, why isn't that being given to Mr. Rogers? Do you know?
I don't.
Mr. Rogers, part of the difficulty of you representing yourself is that there are mechanisms that you can use to compel the state of Indiana to get you this information. And if they respond back and provide some type of legal authority as to why they don't think that they're required, then you would need to counter back legal authority as far as why you are entitled to this. So I don't see that there's a motion to compel the discovery. That being said, I am at a loss why at least the verbatim statements are not being provided, or if the discs themselves are not being provided, I think the state's going to have to transcribe them word for word. I think that just saying that he has to come over and listen to them or watch them at the prosecutor's office when they don't involve certain special circumstances like a feedback interview or something like that, I'm not aware of any legal authority that would prevent Mr. Rogers from obtaining that. Are you, Ms. Cassidy?
I'm just so happy to spend my new year, ringing in my new year with every single person in this chat right now. You guys are awesome. The chat is so good that we miss hearings. And I have some good hearings. Okay, I got some bad hearings. I'm not going to say all of my hearings are great, but we miss the good ones. Bonjour. All right, nope, I can't say that. I don't know how to say that. Bonne et, oh, come on. I know, I don't know. Can someone please English that up so I can pronounce what she just said? Please. Please. Where's Drunken Smurf when I need him?
And I understand that you're just covering the hearing today.
Yes, no, I am not aware. I will obviously pass along all this information to DPA Gruber. And I'm sorry, I
understand. So, Mr. Rogers, I understand your concerns. Your concerns are valid. The trial is coming up in just over 2 weeks, and just trying to figure out how to navigate this so that you have the information. What are you asking of the court today?
Please, does anybody know how to English that so I can pronounce it? Please, Bonnie, and I know that's not even right. Just type it like you would say it in English, because I know that's not. You're.
So you're moving to continue the trial so that you can resolve these discovery issues?
Yes.
Ms. Cassidy, what's the state's response?
state will leave it to the court.
I think in light of the circumstances, Mr. Rogers, it's a valid request. I think what I'd be looking at doing Mr. Rogers, I don't know if February 18th is going to get you what you need, and then if you have to fight the issue out in court, I'm not sure if that's going to be enough time for you, just over a month. What are your thoughts?
You can get it up further than that.
I can. I just wanted to kind of see what you were thinking. So in looking at the other cases that I have set, I think the most realistic next date would be April 1st. Is that agreeable to you, sir? Ms. Cassidy?
Yes, and can I just confirm that CR4 will go to Mr. Rogers?
Yes.
Thank you.
The court will show on motion of the defendant and the state taking no position that the trial that is scheduled on January 14, 2025 is continued to April 1st, 2025 at 8:30 a.m. The court will set aside 2 days to try the matters at issue. I think it would be important to set another final pretrial conference so that we can discuss some of these ongoing discovery issues. And I will set that final pretrial conference.
Bonne et heureuse année. Bonne et heureuse année.
Let's do February 24th at 8:30 a.m. Does that work, Mr. Rogers? Is that acceptable to the state?
Yes.
Okay, so the final pretrial conference is scheduled for February 24th, 2025 25 at 8:30 a.m. And I will show that the delay is chargeable to the defendant for purposes of Criminal Rule 4. So, Mr. Rogers, Criminal Rule 26 requires that you do try to informally resolve the outstanding discovery issues. So, in order to do that, you are going to need to have a conversation with Mr. Gruber, and you're going to have to detail exactly what it is that you want the state to provide. And if you don't get it resolved, then we're going to have to address it on February 24th when we come back. If the state is maintaining its position that it is not required to give Mr. Rogers copies of what he's asking.
That's not what she said. That is not what she said. She said he had access to all discovery, and it was a lie that he didn't. So, yeah, can you hear this, guys? Can you hear this?
Bonne et heureuse année.
Foster's, Bren, I know. So, yeah, she should have just stayed on her hill and died on it, and she just sat there and took it.
Then the state needs to be prepared at that hearing to argue authority as to why Mr. Rogers is being prevented from obtaining this information. So, Mr. Rogers, we'll see what happens, and if you don't get copies of the discovery, then we'll have to have arguments on that when we come back on February 24th. You have any questions?
Shrimp on the bobby.
All that stuff is public information.
It's not, I don't even have access to it. The only thing that I have access to is the probable cause affidavit. That's it. I don't have access to anything else. The state won't let me have access to that. So I guess try to resolve it. If not, we'll come back, and as I've told the state of Indiana, they need to present legal authority as to why you are not being provided these things.
Do the some represented litigant gonna have some same rights as a lawyer have?
I can tell you, at least when it comes to the police reports, that the Elkhart County Prosecutor's Office takes the position that it's considered to be work product, and that they do give it to the attorneys only after the attorneys sign an agreement that they aren't going to make copies of that and provide copies to their clients. So it's a little bit different as far as the police reports are concerned. But again, with the changes in case law that we've had, I think that the state's argument is becoming weaker and weaker on that issue. So that's why I want to hear arguments on the police reports themselves. But Mr. Rogers, I'm at a loss as to why you aren't being provided with copies of the audio or any video recording.
He is.
I don't know why that's happening.
Well, he's allowed to see it. I know a lot of of police departments, things like that, where you have to go in and you have to look at the video there. I don't know. Anyway, they probably gave him a copy. They probably did. But his next question is great.
So I need to hear it from the state when we come back in February why they aren't giving you copies.
That ain't grounds for dismissal or anything.
Mr. Rogers, I don't know that. I can't give you legal advice, and that's another difficult part of...
Can't we just dismiss the case then? They didn't give me discovery. Can't we just dismiss the whole thing?
You not being a trained attorney is because if you're going to make that argument, you're going to have to provide the court with some reason under Indiana law why that might be entitled you to a dismissal. I'm not saying that it would or that it doesn't. I don't know the answer off the top of my head without doing research, but you are going to have to make that motion and provide legal authority if you believe that that is an appropriate remedy. Okay?
Yes.
Anything else?
Yeah.
Anything further from the state?
No, thank you.
Okay, that will conclude the proceedings. That's just your next date.
Are you sure we can't just dismiss the case? Hi, Gemma. Okay, next. don't know what that is, so I'm not going to play it. Anybody want to see an attorney get reprimanded? I do. This guy was a bad attorney. He's still an attorney, by the way. Well, he will be in a couple months, an attorney again, by the way. Bye, Betty. Mwah. Happy New Year.
Everyone have a nice weekend.
It was nice, relaxing.
Yeah.
The judge isn't in yet, but I kept this part in because we've all been in those stupid Zoom meetings with coworkers before, the boss shows up to start the meeting where you have to make horrible small talk. That's what we're going to watch. Painful, just a few moments of painful, horrible small talk.
Yeah, it's almost better in some instances to have the holidays in the middle of the week. You still have your weekend, a little craziness before each one, but you still have the weekend to relax.
That's true.
Oh no, I'm not muted. So this guy right here, he's the attorney that's in trouble.
Staff. The staff is, of course, looking, it's Wednesday, so what are we going to do? If the holiday's Thursday, it's easy. You do Thursday and we're off on Friday. But with Wednesday, we do a Christmas holiday party Monday, then a half day Tuesday, then everybody's back on Thursday.
Yeah.
We're doing the same thing this weekend. This week, we'll do a half day tomorrow and everybody's back Thursday, Friday, except not everybody's back. So it's a sort of scramble to get phone coverage and coverage.
Sure. Oh, yeah. It is, it's tough. People like to back the days off along the holidays to have the extended time off. I'm just shocked it's the end of the year. I feel like it was 2 months ago that I put my calendar on the wall, and now all the months are X'd off and almost all the days of the last.
Who here has a calendar on the wall? Raise your hand if you still put a calendar on the wall. I got my divorce decree on the wall, but calendar on the wall? No. Although if I did have a calendar on the wall, I'm not going to lie, it would be one of those dogs pooping calendars. They're so funny. Now, what do you do with the calendar on your wall when you know what day it is? Your phone just sort of tells you and it's with you wherever you go. Oh, yeah, this cat's getting on my last nerve today, guys.
Last month they're X'd off, and I have to put another one up today.
The end of the season, the end of this year. Good morning, Your Honor.
Thank you, Nancy. Thank you.
Good morning, everyone. This is Judge Bellis. We are on the record in Office of Chief Disciplinary Counsel versus...
Okay. See that judge right there? Get scared, guys. Get scared. Do not mess with her.
Robert Fiddler, Waterbury DMD docket number 24-608-1049. If counsel could please identify themselves for the record.
Good morning, Your Honor. Leanne Larson, First Assistant Chief Disciplinary Counsel.
Good morning, Your Honor. Brendan Levesque from Barry Taylor and Levesque in Manchester for Attorney Fiedler.
And I see Attorney Fiedler is present.
Yes, he is, Your Honor.
Not from my favorite location, Attorney Levesque. I frown upon it when, on the rare occasion when I see a lawyer or a litigant in their automobile for a status conference. But I think for a disciplinary matter, it's highly inappropriate.
My apologies, Your Honor. My apologies.
My apologies, Your Honor. Had I known that this was your position, I would have found office space to move into. I do not have an office of my own. I would have found an office space, but I am not driving. I'm not moving, and the car is off.
I love that.
I understand that, but it doesn't make it any more palatable to do a proceeding like this when you're sitting in a vehicle. And I think we did this remotely to accommodate everyone. And obviously, if we were in the courtroom, we wouldn't have this situation. So I think for future matters, Attorney Leck, please make sure that your client is in an appropriate location.
Understood.
Whether it's your office, a library, there's lots of places that one can go.
Understood, Your Honor. Noted, and I apologize again.
Okay, so let me hear from Attorney Larson.
Good morning, Your Honor. Your Honor, this matter is here on a bypass agreement from the Statewide Grievance Committee. That agreement is attached to the complaint and is also included in the record, which was filed pursuant to the practice book. Attorney Fiedler has admitted that he violated Rule 1.8J, which is engaging in sexual relations with a client, and Rule 8.4, subsection 4.
Oh, lawyer, I know you just did my arraignment, but I don't know how I'm going to pay you.
In that he contacted the complainant's therapist and pastor in an attempt to intimidate, embarrass, or harass her. We have agreed to a
Dude, that's just mean. So he sleeps with his client, which is wrong, and then he goes and tells her therapist, her pastor, and her employer what she did. What? Why? I want to hear this whole story from beginning to end, and I don't get to.
6-month suspension commencing today, subject obviously to Your Honor's approval. Oh, you're muted, Your Honor.
You're on mute, Your Honor.
Thank you. Can you comment, Attorney Larson, on other pending matters?
Yes, Your Honor. There is another presentment that is pending, which includes 3 counts. I think that's scheduled for a hearing at the end of January. Those involve, Your Honor, basically all 3 of those involve allegations that Attorney Fiedler failed to follow through on representation and failed to return unearned fees. He does have a history of discipline.
Can I just ask, no, I actually looked that up, so I understand that. But I don't recall, is he represented by counsel in that other matter?
He is. He's represented by Attorney David DeRosa.
So a different attorney?
Yes.
Yes, Your Honor.
Okay. All right. Attorney Beck, do you want to be heard on why the court should accept this?
Your Honor, I think Your Honor ought to accept this discipline. I think it is a reasonable and appropriate disposition under the circumstances. The point of attorney discipline is to protect and to educate. And I think that the imposition of this sanction does both of those things.
All right. Does your client wish to be heard?
I think he may, Your Honor.
Your Honor, I do not wish to be heard on the agreement itself in terms of the allegations or the discipline that has been agreed upon. My only concern is I do have a client who in 15 days is scheduled for a contested divorce trial. The name of the case, should the court wish to look it up, is Bolding.
I actually looked it up. I actually looked it up already, and I saw that you filed your appearance within, I think, 2 weeks of this current presentment. So I was sort of concerned about that. Can you speak to that, Attorney Larson, that what will happen with that pending matter?
He charged her overtime.
I was unaware that he filed an appearance very recently in that, but we have asked that an attorney get appointed, a trustee, Attorney Johnson be appointed, and Attorney Johnson will immediately contact that client and advise them they need to obtain successor counsel or file an in lieu of appearance, self-representation, and ask the court for a continuance, whatever they need to do. We also immediately send out should Your Honor accept this, we also immediately send out a notice to all of the clerks, the courts advising of his suspension.
But I saw, when I looked up in the case lookup, there I saw for civil and family matters, just 2 cases. I can't remember the other one, but I was sort of alarmed at the appearance that was filed so close to this, the filing of this presentment. I think it was filed after the presentment, as a matter of fact. All right. So, Attorney Levesque, do you have anything to add about that?
I don't, Your Honor. I don't have anything to add.
Your Honor, if I may be heard further, I believe that thank you. I first of all, I believe that the second matter that you may have seen is a matter of Ross versus Wessinger. That is a case pending in the Middlesex Judicial District.
Yes, he charged.
Scheduled for an uncontested divorce, which I've already found successor counsel for my client, and he has agreed to successor counsel for it. Unfortunately, successor counsel does not return from her vacation until January 2. That is what her office
Ozzy, have you ever heard how long attorneys talk before they do something? 6 minutes?
says. That's what her
6 minutes.
instant reply to her emails to her say. But for that matter, Mr. Rolfs does have successor counsel once she returns back to the office. My concern again, I think bowling I was in from the very start. I believe you may have seen that there was a defendant's attorney who may have filed an appearance afterwards. But I believe on behalf, and I don't have anything in front of me, but I believe on behalf of Mr. Bowling, I have been there for some time, and the expectation, like with the Rolfs matter, is that it would settle. It isn't a complex matter. Unfortunately, getting back from the other attorney has been difficult. But the Rolfs matter, I'm not concerned with, so long as I can continue and complete the referral of that matter, because already there is counsel who has agreed, and she just needs to return.
Well, the suspension takes place immediately, as I understand it, and then the trustee will step in. So just so the
I don't
record is
understand that
clear,
word.
I have right now Bowling versus Bowling. That's a family matter, docket 24 docket number, and Attorney Fiedler had filed this appearance back in June. Then we have, I'm going to mispronounce this, Colhone versus Brian, another family matter. That appearance was filed in July. And then I have Rolfs versus Wessinger. That appearance was filed on October 8th. So they're actually, I guess, 3 matters. I said 2, I think, but there are 3 matters. But the trustee will get involved immediately. Do you have anything else to add, Attorney Larson?
Your Honor, I would ask that that Attorney Fiedler forward the information to me, because Attorney Johnson's not in until the 2nd. But if he would forward the information to me as
Attorney Levesque. For Attorney Levesque.
Yes, I'm sorry. Yes, regarding the case where the successor counsel is not due back until the 2nd. If he could forward all that information to me, we will coordinate putting the client in touch with that attorney and see if they can enter into an engagement agreement.
Okay. All right. Anything further from anyone before I canvass Mr. Fiedler?
No, Your
Not for
Honor.
me, Your Honor.
All right. So, Mr. Fiedler, these are questions that I ask everyone. Please don't take them personally. They're not questions that are special for you, but I am going to ask them. Are you presently under the influence of any alcohol or drugs or medication of any kind that would prevent you from understanding what is happening here today?
No, Your Honor.
Okay. Do you have any questions that you want to ask the court or your counsel or disciplinary counsel about this agreement?
No, Your Honor.
Did anyone force you into entering into this agreement?
No.
You're entering into this agreement voluntarily and of your own free will.
Yes.
And would you like the court to accept this as a fair and reasonable agreement?
With my one request of
Get rid of your standards, guys.
being able to finalize the referral of my clients out, which I've already undertaken. I'm down to just these last couple. I would, and I agree. So if this court is willing to defer a little bit on some part of it so that I can, I would appreciate it, but otherwise I understand.
Do you want to respond to that, Attorney Larson?
Yeah, Your Honor, as I stated, I would prefer that the information be forwarded to my office and we'll coordinate that.
All right, I agree with that. Attorney Levesque, do you have any objection to that procedure?
No.
I think that's appropriate.
I will
Right, so-
coordinate with it.
Thank you. All right, Attorney Fiedler. So I will accept the agreement as fair and reasonable. You'll follow the procedure that we just outlined. I know you have another matter, so I will see you on that matter from a proper location. And in the meantime, I wish you the best, and I will enter the order in writing. Anything further today, counsel?
Your Honor, I just wanted to point out, I didn't know if you were aware that there was a proposed order e-filed on October 29th.
Yes, I see it.
Okay. Thank you, Your Honor.
Yes, I did. I read it.
She sees everything. And then there, we're stuck with this for a second.
I think Your Honor
I
froze.
think Your Honor froze. And I'm not getting off until Her Honor's back on.
She's very scary, and now she's smiling, and that makes
Ron?
it worse. Squid Game is so good. It's so good. Your Honor, I have a different smiling lawyer I'd like you to meet.
Ron, are we?
I'm trying to contact her right now.
Okay. I just didn't want to get I wasn't going to get out of the hearing until we heard from Judge Bellows.
Understood.
No, it's definitely not.
All right. I think she's gonna come back on.
Okay.
I got the standby response.
Can't, CJ, I just can't.
All right, I apologize for that. I did freeze up for a minute, and then when I clicked the wrong button and clicked myself right out of the meeting, so it's never easy. Yes, what I was saying was I had read the entire proposed agreement before I joined the meeting, so I will enter the order accordingly. All right, anything
Thank you,
further?
Ron.
All right, thank you, counsel. We're adjourned.
Thank you.
Later would be better.
You got to understand, the longer we wait, the more interest accrues and the less, the more the plaintiff gets. So the chances of you getting anything diminish the longer we go out. What date would you propose?
Later would be better.
You got to understand, the longer we wait, the more interest accrues and the less, the more the plaintiff gets. So the chances of you getting anything diminish the longer we go out. What date would you propose?
I'm not certain because I'm not opening it up again, but I think that was also Connecticut. This is Connecticut too. All right. Is Idaho here? It's time. So listen, I'm trying hard to think, but I don't think I've showed Idaho yet, right? I don't remember showing Idaho yet. And of course we have our lovely Idaho Wiggles. So I have two quick clips from Idaho, guys. Right? Is it Idaho?
Last talked?
Yes, sir.
Yes, it is.
Have you now had a chance to look at what we call discovery?
Now, for those of us who do not live in Idaho, how do you picture Idaho? I picture Idaho like normal, chill, laid back. I don't know, straight. Like there's no excitement, no. It's with potatoes, guys. It's potatoes. There's no spices in there. It's potatoes. You can do so much with potatoes, but spicy hot is usually not one of those things. You cover them in gravy. Yeah. Green and beautiful. Yes. So we're about to watch Idaho. This is Idaho. This is what I think Idaho is. Starting with the tie. And then how he talks to this man infuriates me. I'm going to try to get through it with you, but yeah, I know, but spicy hot chips might be good, but they're not Idaho. They're New Jersey. I don't know, Texas. There we go. Here's Idaho.
I have, sir.
And are you satisfied with that and ready to proceed?
Yes, sir.
Okay. Now, question number 47.
Peg leg, you just missed an attorney get suspended for 6 months.
Asks if you want your attorney to take any further action in this case. Typically, what that means to me is you want to make sure your attorney's here for sentencing and any post-sentence motions you might want to make. But let me ask you this question. Is there anything you need Mr. Parrish to do before I accept your plea today?
No.
Quick question for Mr. Parrish. Mr. Parrish, was this a mediated agreement?
No, I see that he filled that out, and I guess with regard to me talking to the prosecutor, sure, we mediated a bunch, but there was not a formal mediation.
All right, so this was a plea agreement between you, Mr. Hensley, and the state, right?
Yes.
All right.
I agree with that.
Going back to the information, count one. Mr. Hensley, do you admit that on or about November 3rd of 2023, here in Bannock County, the state of Idaho?
Hi, Elisa. It's fine. It's just one time this does this and it's done. Brisket, yum.
You operated a red 2020 Hyundai Elantra and willfully eluded or fled a pursuing police vehicle.
Boom. I mean, think about it. If you're going to flee a police officer in Idaho, what are you going to drive? A Hyundai Elantra.
After being given an audible and or a visual signal to stop, and in so doing cause damage to the property of another or bodily injury to another, or drove the vehicle in a manner likely to endanger the property of another or of another, and or traveling in excess of 30 miles per hour over the posted speed limit. Do you admit that?
Yes, sir.
Mr. Parrish, maybe you could enlighten us.
I think it is, yes.
I was going to say, man, that's a horribly written sentence. It goes on and on and on, but it is actually the facts. Mr. Hensley was officers attempted to, he was on the side of the road, they pulled up, attempted to stop him, and he frankly got scared and took off, ran right towards them and then took off, and they had to chase him around town.
Assuming he was going 30 miles an hour or more over the speed limit?
At least that much, maybe a little more yet.
There was no bodily or property damage?
I think a couple of cars got banged, and I anticipate we'll probably see a restitution request eventually, but nobody got hurt.
Mr. Hensley, do you agree with that recitation of the facts?
Yes, sir.
Based on that, Mr. Herzog, does that mean all the elements of the crime?
I believe so.
And Mr. Parrish, any legal reason I shouldn't accept the plea?
No, sir.
Mr. Hensley, I'm going to accept your plea as being knowingly and voluntarily given. If there is a factual basis for the plea, I'm going to set your sentencing for February 24th. For a pre-sentence investigation report to be prepared, someone from the Department of Corrections will be in contact with you to get that completed. And Mr. Parrish, is there anything else we need to take up?
I did file a new motion to talk about a release today.
Go ahead.
Your Honor, Mr. Hensley's been incarcerated since the end of November of last year. That is because of some of the confusion with regard to arriving at a plea. But I would note it would be his first felony. So he has no prior felony convictions. He does have a bunch of misdemeanor stuff, but he's been incarcerated. He's done a good job out there, stayed out of trouble, and he's got a place to go, and he's actually got a couple of possible jobs he'll be working at and trying to get some things squared away while he waits for a sentence in this matter.
That is a sloppy Joe. It's actually kind of disgusting. It's not very good. It's not delicious. I mean, it's okay. It's fine if that's what you're having, but it's not yummy. You're not missing anything on that one. Promise.
Which I think there's reason to anticipate because of the nature of the charge and the time spent. We're very likely that probation will be a recommendation in this matter. he acknowledges he's got some substance abuse issues he needs to take care of, and he's willing to get involved in that immediately if you were allowed to be released. And so we're asking the court to consider releasing him on his own recognizance. I would prefer to court services with testing just to help him stay on the straight and narrow. He's got family that cares about him. I'd like to see him. They haven't seen him for a while, but he's been in there a good long time, and I think the message has been received. So I'm asking the court to consider releasing him at this time.
Mr. Herzog?
It looks like the court already reduced bond at some point, I think to 15,000. My concern is the risk assessment shows 14 prior FTAs, and I would acknowledge he's been in detention for a pretty good stretch of time. But I think we're close to the finish line here, and I'd just like to see him get everything done, be sentenced, and then be on his way.
Thank you, Mr. Herzog. Mr. Hensley, if I were to release you, where would you live?
At my mom's.
And where does mom live?
Lives at 191 Teakwood, Hotel, Idaho.
Do you have transportation?
My brother, he works for the railroad. He'll be helping me out with rides.
Okay.
And my uncle.
Now, well, let me ask you this. If I were to release you,
Yes, sir.
I would require that you check in with court services and do testing. Is there
Okay.
why you couldn't do that?
Oh, there's no reason why I couldn't. I'd be able to do it whenever I needed to go.
Mr. Herzog has some real concerns about you not showing up based on your history. You understand that?
Yes, sir. Yes, sir.
You understand that if you miss an appointment with either the PSI investigator or court services, and that's going to be a violation of your release, and quite frankly, could avoid the plea agreement here and allow the state to make whatever recommendation they'd like at sentencing. Do you understand?
Yes, sir. Yes, sir. I believe I've learned. I've had a lot of time to think.
Okay. All right. I'm going to release you on your own recognizance to court services with testing. Now, I'm also going to waive the requirement that you pay testing fees for this. So there's no excuse why you can't be there and provide testing when required to do so. Understand?
Yes, sir.
Okay. And I'm also going to require that you meet with the pre-sentence investigator today when you're released. Do you know where probation and parole is?
Yes, sir.
And by where? Where do you know where to be?
So he's been in jail for what? What did he think? What did they just say? Almost a year now? Awaiting, he hasn't even been charged and everything yet. So they're going to let him out after he's been in jail for about a year now.
Or by the courthouse.
Ooh, that's misdemeanor probation.
Oh, yeah, it's felony now. Huh?
Felony probation and parole is at 1246 Yellowstone. It's right behind the Pro Clean Car Wash.
Like Club 91 kind of?
Pardon?
Okay, I know. In there, I know where that's at.
All right, so the building right behind there, there's a bank next door. That will help you, okay?
Yes, sir.
Right now, that's the first place you go today after you get released because you got to check in and get that started, that process started. Understood?
Yes, sir.
Okay. And you commit no further crimes, no new crimes while you're out there, okay?
Yes, sir.
All those things would impact the court's decision making and the state's ability to make whatever recommendation they want, okay?
Yes, sir.
So as Mr. Parrish says, you got a lot riding on this. So I'm going to give you the opportunity to prove to me that perhaps maybe the court needs to consider a probation option for you. Okay?
Yes, sir.
All right. Do you have any questions about that?
I don't.
You want this Herzog?
No, sir.
Okay. Mr. Parrish, any questions about that?
I just want to say, don't screw this up and come see me when you get out.
Yep. Thank you, Parrish.
Yep.
All right, Mr. Hensley, that's as far as we go today. I'll go ahead and excuse you, okay?
All right, thank you.
All right. Mr. Parrish, that does it for you.
That's it. Thank you. Merry Christmas, sir.
You too.
He spoke to him like he was 4 years old the whole time. And, oh my gosh. It's right. We got one more from this court because Idaho Wiggles deserves more than just 8 minutes. Idaho Wiggles needs a little bit more time in her state because we never get to see her state.
Mr. Shaw.
Good morning, Your Honor.
Good morning. You got Casey Cook for arraignment. All right. This is the state of Idaho versus Casey Cook. Case number is 03-24-11854. Ms. Cook is joining us here in person, along with her attorney, Ms. Laura Shaw, and we have Mr. Herzog from the prosecuting attorney's office. This is the time and place set for arraignment. I also have in the file a plea agreement along with a guilty plea advisory. So it appears to me that we've got agreement worked out and the plea agreement will result in a guilty plea today. Is that correct, Ms. Shaw?
It is, Your Honor.
And so let's get the arraignment part done first, Ms. Cook, so then we can proceed to the next step. First of all, is your true legal name Casey Cook?
Yes.
Do you have any difficulty reading, writing, or understanding English?
No.
Ma'am, you've been charged by way of a prosecuting attorney's information with grand theft by a series of thefts. If you were found guilty of that crime, the maximum penalty could be up to 14 years in prison and or a $5,000 fine. Now, have you had a chance to review this information with Ms. Laura Shaw?
Yes.
Would you like me to review it with you, or would you waive the reading of it?
I will waive it.
Now, I also see in the file that you reviewed and signed a notification of rights form, which tells me that you had a chance to talk with Ms. Laura Shaw about your constitutional rights regarding this charge. Is that correct?
Yes. Yes.
Okay. Now, this plea agreement calls for you to plead guilty to this charge. The state, at the time of sentencing, would recommend a suspended sentence and probation. And
That's just not true. We do sometimes. I'll get more if I can. They're just so long. It's just not a clip. It's a week long.
you would agree to pay restitution in the matter.
Yes.
Is that your agreement?
Yes.
Did I miss anything, Ms. Shaw?
No, Your Honor.
And Mr. Herzog, is that your agreement?
Yes.
Now you understand.
All of them.
This appears to be
Every
a
single one of
non-binding agreement on the court. You understand that?
Yes, I do.
Okay. All right. So let me ask you a couple more questions before we get to the plea part here. First of all, you've indicated that you have been diagnosed with depression in the past. Is that correct?
Yes.
But you're not currently taking any medications for that.
No.
Okay. Have you been, or should you be, or anything like that? Let's start with, have you been prescribed medications for depression in the past?
Yes.
Okay.
Yes.
And are you currently taking that medication?
No, I'm not.
Did you stop taking it on your own volition, or did you and your doctor decide that?
I stopped taking it on my own. I started taking it and then I stopped taking it. Like,
How long has it been?
I took it for a month in September.
Okay. And then you stopped.
Yes.
All right. The fact that you're not taking that medication now, is it affecting your ability to understand what we're doing here today?
No, I understand totally.
All right. Have you consumed any controlled substance or alcohol in the last 48 hours?
No.
Is there anything causing you difficulty understanding what you're doing here today?
No.
So, looking back at the information, this charge of grand theft by a series of thefts, are you prepared to enter a plea today?
Yes.
And to that charge, what is your plea?
Guilty.
Now, before I accept your plea, we need to go over the guilty plea questionnaire together. Now, ma'am, did you fill this out in your own handwriting?
Yes.
Or did you have Ms. North Shaw available to answer questions for you?
Yes.
Your signature appears on the back page of the document. To the best of your knowledge, was this filled out surely correct?
Yes, it was.
Now, ma'am, you give up some important constitutional rights when you take them. And I see on page 1 and 2 of this document where you review each right and initial right, indicating to me that you understood what right you were giving up. Is that true?
Yes.
Now, You understand that this is a non-binding plea agreement on the court, right?
Yes.
So the only person that can promise you what sentence you'll receive is me. You understand that?
Yes.
Okay. Now, other than this written plea agreement, have there been any other promises made to you that you should have plead guilty today?
No.
Has anybody forced you or threatened you or forced you to do this against your will?
No.
Are you satisfied with the representation of Ms. Northall?
Yes.
Did you discuss with her the facts and circumstances of the charge?
Yes.
Did she explain to you the elements of the charge and what the state would have to prove in order to obtain a conviction?
Yes.
You understand that the court can order that you pay restitution in this matter?
Yes.
And that regardless of the amount of restitution I order, won't affect your ability to withdraw your plea of guilty in this case.
Yeah. Yes.
All right, now going back to the information, do you admit that on or about, actually it's between the dates of August 1st and September 5th of 2024, you wrongfully took, obtained, or withheld with the intent to deprive another of their property or to appropriate that property to yourself or a third person during a series of thefts comprised of individual thefts, which were a common scheme or plan having an aggregate value in excess of $1,000. It's like $17,468.95, which was the property of the Family Dollar Store by retaining daily deposits in your own possession.
Yes.
Okay. That seems rather self-explanatory, but could you explain to me in your own words what you did?
So I didn't turn in the deposits for 6
I'm
days.
assuming you were working there.
Yes, I was a store manager there.
You're the store manager.
Okay, so the dollar store earned or had $17,000 worth of deposits for 1 week. That does not mean that the dollar store makes $17,000 a week. It's December. It's right before Christmas. You know everybody's getting dollar items right before Christmas. So that's why it is so big. And that's why she waited for this week to say, you know what? I need this more than you do.
Okay. Go ahead. So you would take in daily deposits?
Yes.
And your part of your job was to deposit
Yes.
them?
Yes.
And what did you do with those?
I did not deposit them.
Okay. And so you kept that money for yourself or somebody else?
Yes.
Okay. And that was the intent to deprive Family Dollar Store of that money?
Yes.
All right. And that amount was $17,468.95?
Yes.
Mr. Herzog, does that meet all the elements of the crime?
It does.
Mr. Marshall, is there any legal reason I shouldn't accept your plea? Gentlemen, accept your plea as being knowingly and voluntarily given, and that there is a factual basis for the plea. Now I'm going to set your sentencing for February 24th at 9 a.m. I'm going to order a pre-sentence investigation report to be prepared in this case. In the meantime, you've been released in your own cognizance.
I could. The only problem with that is the only cases that they really televise, live stream, make available to the public anyway are always horrible murders or 17 weeks long or huge big deals. Besides India, they don't really have normal regular court cases. So for a whole week, it would all be murders, and that's a lot. I try not to do murders. Sometimes I do. We watch court videos. People go to jail for murder. So sometimes I do murders, but I'll try. I mean, I've found lots of cases like when that guy broke into Windsor. Oh, and you know, there was a guy that broke into Windsor that I got the sentencing for. There was also another guy that broke into Windsor that I just found out about the other day. He broke in and he sat on the edge of the Queen's bed and had a conversation with her. So obviously this was a bit ago, 1 year, 2 year, 3 year, I don't know. But that's so terrifying. This guy broke into where the Queen lives, sat on the end of her bed and had a conversation with her before someone came in and got him away from her. So I know this is true because the guy who told me had a thick UK accent. So I better believe anything he says, the way he was talking like that. Yeah, that's scary. That was scary. Anyway, let's finish up Idaho. We're at 6, we're almost at 17 full minutes in Idaho. I hope she appreciates this.
Court services. Any objection if that continued, Mr. Brazil?
No, sir.
All right, so I'm going to continue your release on the same conditions with the understanding and the promise that you'll stay in contact with Ms. Shaw and that you'll cooperate with the probation department of corrections with the pre-sentence investigation. Have that promise?
Yes.
We promise to be here on February 24th at 9 a.m. for sentencing.
Yes.
Correct. All right, Ms. Marshall, is there anything else we need to take out? Your Honor. And Mr. Herzog, anything else we need to take out?
No, sir.
All right, then I'll excuse you. Check in with Mr. Carlin there at the desk before you leave and give you some additional information on the PSI. Thank you very much.
Thank you.
So that was Idaho.
Marshall, that does it for you, right?
It's time.
Thank you.
It's time. I don't know when it happened. I only found out because this guy came into my bar. He's one of my regulars there, and he's from the UK. And I told him about the clip that I showed with Windsor, and then he told me this whole story. And I believe him. He doesn't lie. So that was just scary, 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 scary. It's time, guys. It's time. Delusions of grandeur. That's what we're about to run into.
Okay. Anything else ready, Mr. Smith?
Yes, Your Honor. We can call the Gabato matter.
All right. Jeremy Gabato, cause numbers 480882514, 480500458, and 480367682. Mr. Gabato, good morning, sir. You can come on forward just in front of the screen. How are you? Good. All right. So these are all on for arraignment, and they were all returned warrants as well. I guess we'll go ahead and proceed. Mr. Smith, are you ready on arraignment?
Yes, Your Honor. I've gone over Mr. Gabato's rights and believe he understands them. At this time, we will waive formal reading, stipulate the probable cause for the purpose of this hearing. We're prepared to enter a not guilty plea.
All right, Mr. Gabato, I'm going to waive any further reading then at counsel's request. I'm entering pleas of not guilty on your behalf to all of the charges. And then with that, Mr. Kilfoyle, would the city like to be heard on conditions?
Yes, Your Honor. At this time, the city would be asking for $2,000 appearance bond on each of these cases. We would also be asking for the defendant to surrender plates if he posts that bail and not to drive without a valid license and ignition airlock devices he is required to do at this time. I note for the record the defendant has quite a bit of driving history, quite a few pending matters as well. So I believe that's the least restrictive means to ensure his compliance at this time.
Thank you, Mr. Kilfoyle. Mr. Smith, would you like to be heard on that?
Yes, Your Honor. We just ask that he be released on personal recognizance. He is self-employed, clears roads. He volunteers cleaning roads after storms. And during storms and collects firewood. He is on food stamps as a public defender, already assigned in his district court matter. So in addition to requesting the PR release, we would ask that he be assigned a public defender from the bench. Thank you.
All right. Well, I'm going to reduce the bail. The bail is set at $3,000 cash on all three of these. I think probably because of how many no IID charges are pending and how many convictions there are in the past. I'm just counting right now. We're up to 1, 2, 3, 4, 5, 6 pending IID charges. We also have, it looks like, several prior convictions, if I'm reviewing the history correctly. I also counted almost 50 cases with warrant history. So I think the city's request is perfectly reasonable here. It's a pretty substantial reduction from $3,000 cash on each. I'll set it at $2,000 bond on each or $200 cash alternative. So it'll be $600 total with between all three cases. Yes, Mr. Gabato.
I'm an asset to the community. There's a couple of things that never get brought up. During that bad storm out in Sun Valley, the WTA bus was a sitting duck. If I would have been out there with my chainsaw, that lady driving the WTA bus would not have made it home that night. Deputy Lorene was en route, and he told me to turn around. It was useless. I kept going. I cleared 3 big trees out of the road. During the storm, the traffic was backed up both ways. That WTA driver, I escorted her all the way back to town during the storm. 2 weeks before that, I got shocked. I got shocked clearing the road by the lines. I kept the road
Mr.
clear.
Gabato, I understand what you want to share with the court. I'm going to advise you at this time to exercise your right to remain.
I'm advocating for myself because nobody does.
But you're also potentially admitting to driving, and so I would prefer that you not do that on a public record where that can be used against you.
It's already on public record. I'm an asset to the community.
Mr. Gabato,
I save people's lives.
Here's where I'm at, sir. I don't disagree with anything that you said. If that's all true, and I'll take you at your word that it is, obviously that is a pretty substantial gift that you give to the community. But here's where I'm coming from, sir. You have 50 cases with warrant history. I'm showing at least, let's see, 1, 2, 3, 4, 5, 6 cases with active warrants. That warrant history it simply suggests to me that you're not likely to appear for court. And so I think that I think what I've imposed here is completely reasonable, Mr. Gabato. I understand you don't agree with it.
How much is my bail?
So it's going to be total of $6,000 bond or a $600 cash alternative. And that is based, A, on appearance history. The court does make a finding there is some flight risk here. And B, the fact that as I counted, I think you have 6 or 7 pending no IID charges. That does cause me a lot of concern, particularly for community safety.
And during all those, I've never been under the influence. I don't drink or do drugs through all those. I've never been under the influence, sir.
Okay. Well, Mr. Gabato, I'm noting your objection for the record, but I have to be completely blunt. I feel very comfortable with the bail amount that I've ordered. I think it's appropriate based on the history that's been.
Could you cut it in half, please? Could you cut it in half?
Sir, I'm going to leave it exactly.
I'm not a flight risk. Everybody knows where I am.
Mr. Gabato, I understand your position. I do. I hear what you're saying, but I think that it's set appropriately.
You've let people go today with worse crimes, for
Mr.
less.
Gabato, at this time again, I'm just going to remind you that I'd advise you to exercise your right to remain silent.
The conditions here, Mr. Gabato, pretty straightforward. Appear timely for court, have no new criminal law violations, and do not drive without a valid license and proof of insurance. So those are going to be the conditions.
You're going to hold me in here for traffic stuff?
Mr. Gabato, your history is pretty significant.
I did do one of those things.
And I understand you don't think no ignition interlock charges are significant, but they are significant. It means you need to be driving only with an ignition interlock. And the allegation here is that on numerous occasions, you have not. Not only that, but you don't come to court. You have active warrants in Bellingham, Whatcom County District Court, Linden, Skagit County District Court. You don't come to court. So I'm going to go ahead and sign off on the order here. I understand you disagree with me, and that is completely fine. That is your right, but I have made the decision, and I feel comfortable with it. So your next court date, Mr. Gabato, going to be in custody January 13th at 8:30.
I put the oil beside the chainsaw. I put the funnel beside the oil. So I have the cord ready. I have the chainsaw ready. I have the oil ready, and I have the funnel ready, all in a row. I just got rid of a mountain of wood chips. The wood chips are all gone. Now I can work on the chainsaw.
If the bail is posted, then it'll be on February 25th at 1:30 in the afternoon. I am also ordering that you surrender plates to any vehicles that you own. I think that's entirely appropriate given the number of driving charges that we have here today. So you would need to report to the probation department only to surrender plates. They're not going to be monitoring anything else. That pretrial supervision would end once those plates are surrendered. So there we go. I'm going to go ahead and sign off on that, Mr. Gabato, and I've noted your objections, sir. Thank you. Be just 1 minute, Mr. Smith.
Oh, hell no. Hell no. The last thing I would do is let any of the men in this house operate the chainsaw. No. Because you know what would happen. And this is true, though. I can't believe we don't see this on the news more often. They would try to start it. They can't start it. They can't start it. They would put it right between their legs so they could pull on it harder. Yeah, that's exactly what happens. I know it. I can see it. Yes. Oh, no. I am sick and tired of this. I can't get coffee in the morning anymore. I'm going to have to go brew coffee in the kitchen. No. All right. Let's see. Listen, I want to call 911 for firemen every night, but I don't. I have self-control. Tiny bit of self-control. Not really. I don't really have self-control. Is this Fleischer? No, that's not it. That's not. Right? Uh-oh.
Is Mr. Dennison?
Anita Coleman.
Uh-oh. It looks like we're going to have to do this, Fleischer, and I think the other one's upstairs. It'll take an hour or two to get downstairs. Yes, my chainsaw is electric because that was cheaper than gas. My weed whacker, however, I went all out on, and I got gas. I just don't have any string left for it, so I can't use it. Oh, don't work today. Call in. Oh, man. January 1st is my worst day of having to work. I remember when... Never mind. Let's just watch some Fleischer. We didn't see this beginning part. I fast-forwarded through it. So, here we go. This guy looks nice. Look, he looks appropriate for court.
Good morning, Mr. Mayor. Do you have a lawyer today? You have a lawyer? Who is it? Okay, so why don't you just take a seat and we'll wait for this person to get here, okay?
All right, Judge, next is page 9. Is Gara Edwin? Come on up.
His license is eligible.
Did you hear her voice? Can we hear that again, please, please, please?
This is page 9. Is Gara Edwin?
Oh,
his license is eligible, Judge.
It's like she's talking directly to me. Don't know what else to call it other than weed whacker. What else is it? Lawn trimmer? What's another word for weed whacker? Is that not the right word? What do people in Australia call weed whackers?
Sir.
Morning. Hey, but I need a little bit of practice on that job. I started working like 2 weeks ago.
You doing?
84 lumber company on Fraser, by Conroe.
How much money are you making a month?
Well, I'm gonna get my first paycheck.
I'm about to get my first paycheck. Okay. How much money are you making a month?
Like $17.50 an hour.
And I was wrong. We did see
Did you
this
want to apply
yesterday.
for quote-unquote lawyer, sir?
So I'm going to go
Did you wanna-
over here. Oh,
Yeah.
here.
Okay.
You, Judge, thank you.
And we saw
Okay.
that. All right. I'm going to find one or two we didn't see. Hi, Carol. And then string trimmer. Strimmer. I'm just going to call mine Bob. No, I'm not. That name's taken. We saw him. All right, guys, we're good. We're done. We're going to do We'll do today's Judge Fleischer tomorrow. Idaho. Did Idaho just wander in? Did I miss Idaho wandering in? Idaho, you're late. I have Idaho in the docket today. I think it's like 18 full minutes of Idaho for you. Yes. Watch. Idaho's going to say, oh, well, I really live in Jersey. I just like that name. and then and we all watched that 18 minutes of Idaho for nothing. Okay, I'll call my weed whacker Fozzie. Fozzie, get to work. Fozzie, you're out of string. Fozzie, I need a longer string. Because, you know, to get a longer string, you, like, bang it on the ground. Okay, don't bang it on the ground like that, guys. So just break it. You tap it lightly, and the string comes out. All right. I'm going to queue up OJ. But first, I gotta go make coffee because apparently Dunkin' Donuts doesn't like to work. So, he needs more gas. He needs more gas. Happy New Year, everyone. See you, whoever comes into OJ next. See you there. If not, I don't know. We'll see what happens today. Thank you. Happy New Year. Bye. Have a good night. Day. I'm going to find my video.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. To the night, her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue, in her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray,